Good afternoon, everyone. Just
Yeah.
wanted to know if you can all hear me. I'm just trying to
You can
share
be a
my.
little loud, and that's
Oh,
we can hear
yeah.
you.
I'm just going to put on my mic closer. I'm just trying to share my screen. If you just give me a couple of minutes.
Sure.
Uh, and, anyway, I'm just getting a notification that host disabled participant screen sharing. But if I can't, just try again. Okay. All right. Is it fine for everyone? Can you, do you see the screen?
Yes, we
All
can.
right, thank you. So I'm just going, first of all, allow me to say thank you to the organizers for giving me the opportunity to make this presentation. So Your Excellency, Sarin Anirudh, Honorable Member of Parliament, fellow participants, and distinguished participants. My presentation would be on the law of the sea, the United Nations Convention on the Law of the Sea. So I will look at the legal aspect, if you want, of the sea. I have listened carefully to what my fellow panelists have said, and I concur with what have been shared. And I'm going to provide you with the legal framework. So just an overview of the United Nations Convention on the Law of the Sea. So the convention was the law of the sea. If you want the law of the sea, just one more, here we go. So the law of the sea emanates from customs. Customs created, various customs at sea was made. For example, the most important custom that we have at sea is having a flag at sea. So today we have the United Nations Convention on the Law of the Sea, which actually is mandatory that ships have flag, but this custom of having a flag, this situation of having a flag emanates from custom. So the very first source of the law of the sea is custom. And after the Second World War, uh, the United Nations was created and a series of conventions were put forward which regulated activities at sea. But as from 1982, the United Nations Convention on the Law of the Sea was created. And up to today, it is the main legal framework which regulates activities at sea. So just like on land, we have a constitution which regulates the activities of people, which provides for the rights and freedom of the citizens. The sea has its own constitution. And that constitution is, as I've said, the UNCLOS, United Nations Convention on the Law of the Sea. Now, this constitution for the sea provides for three major elements for activities to be conducted at sea. And those three major elements are the extent of national sovereignty. So to what extent a state, coastal state, has sovereignty over the sea? What are the navigational rights of ships and aircrafts as well? And finally, it provides for environmental protection. So I'm just going to give you a brief overview of these three pillars of the UNCLOS. So delimitation of national sovereignty. If I can say from the eye of the law, the sea is just a series of division. So starting from the baseline is an invisible line, which actually separates the land from the sea. So that's the first layer of division. So we have the baseline, which divides the land from the sea. And then we have what is known as the internal waters, territorial sea, contiguous zone. So from the baseline up to the contiguous zone, a state has sovereignty, meaning that the state has full civil and criminal jurisdiction within these different divisions at sea. And then we have the exclusive economic zone and the continental shelf. So one interesting legal point that we can make here is that within the EEZ and the continental shelf, a state has sovereign rights, which means that any activities which goes on within that region, within the EEZ or continental shelf of a particular country, any foreign vessel coming or undertaking any form of activity within those regions has to seek the permission of the coastal state for that. And then we have the areas outside those first 6 layers, which is the high seas, the area or the high seas. Now, the high seas, there's a saying within the realm of international law, the high seas belong to no one and everyone. at the same time, meaning that no state can claim sovereignty over the high seas. However, all states, whether landlocked or coastal, can explore or exploit the resources within the high seas. So the first part of the convention actually provides for all the regulations, the do's and don'ts of what states can do at sea. So I have just highlighted those 7 layers of division, and each one has its own, as I've said, inherent characteristics. Now I'm going to look at navigational rights. I think that Captain Palmer already discussed about, and the fellow panelists as well discussed about some of the duties of shipping regulation at sea. But one thing which is very important is the duties of ships on the high seas. As we can see, when a ship enters the territory, the marine territory of a particular state, the laws of the state will apply. But what happens on the high seas, which doesn't belong to anyone, but at the same time, it belongs to everyone? So this is where sailing under flags is very important. So from a purely legal perspective, whenever a ship is on the high seas, the flag being shown on top of the ship represent the state, the jurisdiction where the ship comes from. And anything which happens on board of that ship, it falls within the exclusive jurisdiction of that state. So this is why it is very important for ships to have a flag, so that any activities which happens on the high seas, the state has jurisdiction to hear any case, so entertain any case when something happens on the high seas. So I've just highlighted some principles and activities which are forbidden, which you can have a look at in the UNCLOS. Some of the activities which are considered forbidden by the law and which cannot be done on the high seas. And now something which is very important, and some of you highlighted it before, the environmental principle. Actually, the UNCLOS is, I would say, one of the first international instruments which talks about protecting the marine environments. Many of us, when we talk about the blue economy, we talk about exploiting marine resources, we need to talk about environmental protection. We have seen oil pollution has caused the destruction of a tremendous amount of marine ecosystem. So the UNCLOS provides for the conservation and protection of marine resources. So this is one, I would say, brilliant part, one very, something which is commendable about the UNCLOS. It was one of the very first conventions to talk about the protection of marine resources. So Articles 61 and 62, and there's the list of articles as well, but the two most important one are Article 61 and 62, which actually provides for the conservation of marine resources and how to utilize marine resources. And just to maybe drop this in the debate, so one way actually to reconcile exploiting marine resources and providing for the conservation of marine resources is through marine spatial planning. So marine spatial planning is one of the elements that can be considered when developing the blue economy to strike the balance between using marine resources and at the same time providing for the protection and conservation of further marine resources. Now, just to provide for a critical analysis of the UNCLOS. So just like any piece of legislation, it has its strengths and weaknesses. So as I've said earlier, the UNCLOS is the constitution of the sea. It is the very first actually document which provides for the do's and don'ts at sea and provides for the regulation of maritime activities. As we have seen, it provides for the delimitation of maritime space in order to avoid conflict. So probably some of you might recall, before the creation of the UNCLOS, many states were fighting, conflicts were created because of a state didn't know when or how to delimitate their maritime space. So with the creation of the UNCLOS, this reduced, even though there are still conflicts, but with the creation of the UNCLOS, it provided for a framework where states know to what extent of sea belongs to them. Another strength of the UNCLOS, it's about marine environment protection and conservation, as we have seen. And more importantly, it provides for a set of harmonized rules, which applies to all countries. So as when you become a member of the UNCLOS and you have signed and ratified the convention, which is the most important part, the ratification part, the rules which applies to Mauritius, the same rules will apply to India, will apply to other states which have signed and ratified the UNCLOS. So this provides for harmonization of rules and avoids maritime conflict. Now, some of the weaknesses of this UNCLOS, the UNCLOS cannot operate without ratification. So ratification means that a country has to turn this international law into their national law in order for it to become effective. So many states up to now, unfortunately, haven't ratified the UNCLOS. And when you don't ratify it, it doesn't have force of law on you. So one weakness is that states should take into consideration the advantages of the UNCLOS and ratify it within their national legal system. And one last point, and this is one criticism within the academic community, is about the delimitation made. So delimitation of the UNCLOS is a man-made delimitation. It's not about a human, it doesn't consider really the natural delimitation of things. For instance, when we talk about the high seas, resources falling outside or not, somehow I put it in between inverted commas, protected by national laws. Yes, they are protected, but because they don't, because of the non, I would say because they don't fall within a certain national delimitation, some countries might forego the UNCLOS and exploit extensively some of the natural resources falling within the high seas and outside national jurisdiction. So I think I just, my point was just to make a brief overview of the UNCLOS, and I would be glad to answer any question during the Q&A if participants have any question. So thank you very much.